spraying a gun into a crowd and saying, well, I didn't intend to kill anybody.
I can't stop you, or can't stop other people from killing people, but I can stop you from doing it again in this time.
Jordan, I know you ain't do that. They seen what Carl was on top of that nigga. I'm taking it. I'm taking it.
In April 2022, Kenneth Twyman, a 25-year-old from Milwaukee, was involved in a tragic incident that resulted in the death of 24-year-old Taven Luckett. Twyman was charged with first-degree reckless homicide and possession of a firearm by a convicted felon. During the incident, Twyman was driving recklessly and shot Luckett outside a store near Fond du Lac and Locust. After the shooting, Twyman fled the scene, and it took several months before U.S. Marshals arrested him in Oak Creek. He had been named one of Wisconsin's most wanted fugitives 3 times. Twyman stood trial in 2023, where he claimed the shooting was an act of self-defense.
There is an old saying that it takes 2 to tango.
However, the jury and judge rejected his defense, and he was convicted of first-degree reckless homicide and possession of a firearm by a convicted felon. The court found that his actions were reckless and unjustified, despite his defense. The judge pointed to his history of criminal offenses, including multiple open cases, and those crimes that he committed while out on bond, further complicating his case.
The pattern of lawlessness, multiple open cases, committing new crimes while out on bond.
Twyman also had a history of avoiding legal responsibility, as he skipped court hearings 6 times.
Can you be lenient in my sentencing? For I'm not who they pay me out to be.
During the sentencing in May 2023, Luckett's family expressed their deep grief. They described Twyman as a coward with a gun and spoke about the pain his death caused. Twyman, in return, apologized to the family.
Kenneth Twyman played God with a gun that he had no license to own. What has Kenneth Twyman done with his life here on earth, other than being a menace to society? He is a coward with a gun.
Intention to create that persona for yourself of being a threat.
This man has been the devil agent here in our community.
And I would like to ask the family to accept my apology, and I'm sorry.
The judge sentenced Twyman to 35 years in prison with an additional 15 years of extended supervision, emphasizing the severity of his actions and the risk he posed to the community. In January 2024, Twyman faced further legal consequences when he was sentenced to an additional 10 years in federal prison for drug and weapons-related charges. These included dealing cocaine, marijuana, and heroin while armed with a machine gun in 2018, possessing marijuana in 2022, and making false statements to a firearms dealer. His federal sentence will be served concurrently with his state sentence. In November 2018, Daquavius Jamal DJ Howard was arrested in Macon, Georgia, in connection with the death of Michael Antoine Chapman. Howard faced charges of armed robbery and murder. The arrest followed a violent altercation that ended tragically, and Howard was held without bond. As the years passed, the case made its way through the court system, and eventually, Howard stood trial for the charges against him. During the trial, the court heard emotional testimonies from both the prosecution and the defense. Finally, after months of legal proceedings, the judge made a statement at the sentencing.
Now, you and you alone are responsible for all of the grief that comes with that. You are responsible for every bit of anguish and agony that everybody on that side of the room feels, including your own family.
The judge addressed Howard directly, acknowledging the profound impact of his actions on both the victim's family and his own. He spoke about the deep sorrow felt by everyone in the room, emphasizing how the families of both Howard and the victim would forever be changed.
If I live to be 1,000 years old, son, I will never understand why it is that in this community we settle our differences with a gun. To a greater extent than I see in a lot of other places. The only good thing about the coronavirus pandemic was that I got a year off from having to sit in this room and look at dead bodies on that screen and young men at that table who had killed them. For years, I do it all the time.
The judge expressed his frustration at the frequency of violence in the community, remarking that it had become a way of handling disputes. He also mentioned that, despite a brief respite from such cases during the pandemic, he had consistently faced similar tragedies over the years. He shared his confusion about why the community resorted to violence to solve problems.
And it's sad, and I don't understand. 2 lives have been thrown away. Yours and Mr. Chapman's. And 2 families will never be the same. All because of the choice that you made. And it's a choice that way too many people make around here. Son,
The judge further highlighted the devastating consequences of Howard's choices, noting that 2 lives had been lost, Howard's and Mr. Chapman's, along with the irreparable damage to 2 families. The judge spoke about the importance of making different choices and emphasized that the cycle of violence needed to end.
it's a sad day in this room for everybody in it. And Mr. Schoolcraft is right. Sending you to the penitentiary may not stop the next guy, or the one after that, or the one after that. But word needs to get out. We're back in business down here. I can't stop you, or can't stop other people from killing people, but I can stop you from doing it again in this time. And that's what I aim to do, son. I want you to remember for the rest of your life how everybody on that side of this room is feeling right now. Mr. Chapman's family will never see him again. Your family will never see you again outside of the prison.
In closing, the judge acknowledged that sending Howard to prison might not stop the next person from committing similar acts, but it was necessary to send a message. The judge made it clear that Howard would not have the opportunity to repeat his actions, ensuring that he would not be able to harm others in the same way again. He was sentenced to life in prison. On January 16, 2017, Elizabeth Faye Cannon, 48, fired at Vernon Marcus Jr. and his friend as they walked past her home on Bloomfield Drive in Macon, Georgia. The shooting left Marcus critically injured with a gunshot wound. Cannon claimed she fired the shots to scare the boys, alleging that they had been throwing rocks at her house.
After speaking with the responding deputy, Deputy Young, he stated that Ms. Cannon had admitted to him of firing several shots just to scare the gentlemen that was walking near her property, and she didn't mean to hit one of them. And she one of the bullets ended up striking one of them in the head, back of the head.
However, investigations revealed no damage to the house and no evidence supporting Cannon's claims. Cannon's daughter testified that there were no rocks thrown at the house and no prior threats had been made by the boys.
There was a previous altercation with some youths, or are they the same youths?
I'm not sure, sir.
Okay. And was the victim injured on this woman's premises or off her premises?
Just off the edge of the premises.
Right at the edge of it. Is there anybody other than the young man who was injured that's given a statement? I know Ms. Cannon gave a limited statement. Are there any other witnesses to this?
Well, the victim didn't give a statement because he's been treated, but the other guy that was with the victim pretty much stated that they had walked to the store, they was walking back to their house, and just as they passed Ms. Cannon's house, they heard several shots coming from that area. And he looked back, he saw that his friend had been hit.
So his testimony is while walking lawfully down the sidewalk without making any contact with Ms. Cannon.
The shooting left Marcus critically injured with a gunshot wound. A witness who was nearby confirmed hearing several shots, but did not see any direct confrontation between Cannon and the boys. The defense questioned the justification for Cannon's actions, noting that she had called the police in the past and had previously experienced issues with the individuals involved in the incident.
Only thing he admitted, he stated that previous in the past, she had been calling the police on them, had been harassing them, claiming that they've been breaking into her house, had been doing different stuff to them, And he also said that she's used several racial slurs towards them.
In the past, it sounds like she's called the police for intervention and help. What did the witness tell you was different about this day, where a handgun was used or a firearm was used, as opposed to asking the police to step in?
Say that again now.
You know, it just sounds like in the past she's calling for help. She's calling for the police to come out to help with minors who were causing trouble on or about her premises. What's the justification for the difference on this particular incident if no contact was made?
I have no idea.
No clue. Okay, that's all we have for today, Judge.
Cannon's defense argued that she acted out of fear, but the prosecution stated that her actions were reckless and unjustified, as there was no immediate threat to justify the shooting. During the sentencing, the prosecution presented body camera footage showing that Cannon had previously discussed using her firearm to deal with perceived threats. It was reported that Cannon used racial slurs when confronting people outside her house in the past. Cannon's defense attorney cited her health issues and stress, requesting a more lenient sentence. However, Judge Howard Sims emphasized the severity of the crime and the need for accountability. As a result, Cannon was sentenced to 20 years in prison, with 15 years to be served and the remaining 5 years on probation. In addition, she was ordered to pay restitution to cover Marcus's medical expenses. Andrew Mullis appeared in Bibb County Superior Court seeking bond after he was charged in the shooting death of 42-year-old Dedrick Bulls in December 2022. Mullis turned himself in following the incident, which he claims was an act of self-defense. According to Mullis, he was approached by 3 men, including Bulls, who were armed. Fearing for his safety, Mullis testified that he retrieved his from his vehicle, but did not immediately use it. Instead, after a brief exchange, he fired the gun at Bulls.
Aimed at me in a grist with him.
And what did you do?
I got scared and I let off one shot.
Mullis admitted to having consumed alcohol before the shooting, though he was 19 at the time, and confessed that he ran from the scene afterward. His defense team argued for immunity, stating that Mullis's actions were justified, but the prosecution contended that his response was unreasonable. Judge Jeffrey Monroe questioned why Mullis did not leave the area after retrieving his gun, pointing out that there was no clear indication that the situation was particularly dangerous.
Why didn't he at that point get in it and leave?
The defense explained that Mullis was waiting to lock up after his shift at Full House Tavern, but the judge found this reasoning insufficient.
This particular instance, there is no body language that indicates that this was a tense situation.
Consequently, the motion for immunity was denied. The family and friends of Dedrick Bulls expressed their grief at the decision, with Bulls' girlfriend, Katie Mayo, emphasizing that no one could ever replace him.
Trying to fill the void and the whole of the man that he was is impossible. There will never be another person like Dee.
Despite the ruling, Judge Monroe granted Mullis a $100,000 bond with conditions. If released, Mullis will be required to wear an ankle monitor, live in a neighboring county, and refrain from contacting any witnesses in the case. He is also prohibited from entering Bibb County, except for legal matters related to the trial. In December 2020, George Reel, 25, was involved in a fatal crash at the intersection of 60th and Burley in Milwaukee, resulting in the death of 36-year-old Arthur A.J. Baker. Reel, who was driving recklessly, ran a red light, sideswiped 2 cars, and caused his vehicle to flip over, fatally striking Baker. Reel pleaded guilty to 2 charges: second-degree recklessly endangering safety and operating a vehicle under the influence of a controlled substance. At his sentencing in Milwaukee County Court, Judge David Borowski described Reel's actions as reckless and ruthless, emphasizing that he was a serious danger to society. The judge compared Reel's driving to firing a gun into a crowd, highlighting the extreme disregard for human life.
This is utter disregard for human life.
During sentencing, a disturbance occurred when a friend of Reel was removed due to secretly filming in court. He was removed immediately.
Take him out of the building.
Check the time. George, I know you ain't do that. They seen what car was on top of that. I'm taking it.
Reel expressed remorse in court, stating that he would do anything to go back and change what happened.
I am sorry and would do anything to go back in time and change things. I never meant for anybody to get hurt or killed.
Mr. Reel, your driving is the equivalent of spraying a gun into a crowd and saying, well, I didn't intend to kill anybody.
However, Judge Borowski pointed out that Reel had been out on bail for another reckless driving case at the time of the crash, further demonstrating his ongoing dangerous behavior. The judge also criticized the bail system for allowing individuals like Reel to remain free while posing a danger to the community.
Mr. Reel, you are the poster child for two of the biggest problems we have in the city of Milwaukee and Milwaukee County. Not just reckless, but ruthless driving and people being assigned bails that are too low.
The court noted that Reel's actions needed to be punished, not just to hold him accountable, but to protect others from further harm.
But I want to make it very clear. Mr. Reel is an extreme danger to the community. He's an extreme danger. In fact, I think he's a certainty to reoffend.
In addition to his 20-year prison sentence, Reel will serve 15 years of extended supervision after his release. The judge granted the maximum sentence, in part due to a request from Baker's sister, who urged for the harshest penalty possible. In November 2024, Darius Tyson, a high-ranking member of the Blood Gang, was accused of engaging in illegal activities from his jail cell. Prosecutors claimed that Tyson used his influence to orchestrate drug deals and smuggle drugs into the Durham County Detention Facility using an illegal cell phone.
My understanding in speaking with one of the rank over at the jail that there were on the phone, they were able to verify him setting up drug transactions and money drops.
Additionally, Tyson was accused of having sexual relations with 2 female jail workers, which led to pregnancies. Tyson's defense attorney argued for a reduction in his $1.25 million bond, suggesting that Tyson was a victim of assault and could not consent to the alleged encounters.
He was assaulted. A detainee by law cannot consent. He is a victim in those cases.
However, prosecutors opposed the bond reduction, presenting evidence of Tyson's ongoing criminal behavior in jail. The court denied Tyson's request to reduce his bond, keeping him in custody as he faces the charges against him.
What do you think he wants to tell everyone?
He's innocent. He's innocent.
Of all the charges?
Of all the charges.
Tyson's mother, Marette Tyson, claimed that her son is innocent and was unfairly targeted by law enforcement. She also mentioned that Tyson had been assaulted by jail staff, although the sheriff's office denied any record of such incidents. Tyson is also facing charges related to the 2022 disappearance and presumed murder of Sean Burton, a 44-year-old father of 6. Burton was last seen on March 22, 2022, and his body has not been found. Tyson has been charged with murder, conspiracy to commit murder, kidnapping, and burglary in relation to Burton's case. In January 2025, Tyson remained in custody at Central Prison in Raleigh, North Carolina, awaiting trial. His trial for the murder of Sean Burton is scheduled for February 2025, though his defense attorney has suggested that the trial may be delayed. Samantha Woll, a well-known Jewish community leader in Detroit, was tragically murdered in her home. Her death led to a high-profile investigation and trial that culminated in a controversial verdict. Samantha was deeply involved in interfaith relations, having founded the Muslim-Jewish Forum of Detroit and later serving as president of the Isaac Agree Downtown Synagogue. She was widely respected for her efforts to bridge gaps between communities and promote peace. She was last seen returning home after attending a wedding. Shortly after, she was attacked inside her residence. A neighbor later found her body on the sidewalk outside her home, prompting an immediate police investigation. Authorities initially detained an acquaintance, but released him without charges. After an extensive investigation, 28-year-old Michael Jackson Bolanos was arrested and charged with murder, home invasion, and lying to police. A key moment in the trial was the testimony of Samantha's sister, Monica Rosen. She described her close relationship with Samantha and her shock upon learning of the murder. She also recalled conversations with detectives in the early hours after her sister's death, where she mentioned an individual named Aaron. She initially described Pergam as a stalker, but later clarified that she had used the term casually and had no real basis for it.
You had an opportunity to speak to detectives in the investigation of this case, correct?
I did.
Okay. And you and Samantha were close since you were sisters, correct?
We were.
Okay, and she spoke to you about sometimes individuals she knew in her life, correct?
She did.
Okay. and she mentioned an individual by the name of Aaron Pergament, correct?
She did. She knew him for a very short time.
Very short time? Okay. And you, based upon your conversations with Samantha, you in fact told detectives that Aaron Pergament was a stalker of Samantha Woll, correct?
When I was interviewed by the detectives, it was hours after my sister was murdered. I threw out many words very casually because my state of mind was not how I normally exist in the world.
Okay.
I was in extreme shock and stress. I said he was a stalker. I had absolutely no basis for saying that whatsoever.
Okay.
I'd never even met him before.
Okay. You didn't use that same phrase in reference to other individuals that you mentioned to detectives. Would that be fair?
I did not.
Okay.
You have to understand, my sister was beloved by many people, whether she met them for 2 minutes or she knew them for her entire life. And this particular person also really liked her, and that's what I was telling the police.
Okay.
I wanted to be as cooperative as possible.
Absolutely. And you were trying to help them in their investigation, correct?
Correct.
And at that point in time, you went through your memory bank of any information that you felt could have been pertinent. Is that true?
Correct. And I also, in that same interview, said he was a very upstanding person from what I had heard about him.
Okay. But you mentioned that he was a stalker more than once during that interview, correct?
I did, and again, I said this extremely casually. I meant absolutely nothing by it. All I meant was that I knew that he liked her and he would text her, and I did not know how my sister felt about him.
Okay. And you knew that we're conducting a criminal investigation, correct?
I did. I've never spoken to the police before for any reason whatsoever, so...
Okay. Would you agree that calling somebody a stalker is a pretty serious accusation?
In hindsight, again, this was hours after my sister was murdered, and I was living a nightmare, and so whatever frame of mind I had at that time was completely different from what I would do on a normal day.
Okay. Did you ever contact that same detective to supplement your report and say, Detective, I apologize on what I said about Aaron Pergament. I want to set the record straight. He's not a stalker.
I talked to the detective many times, and I don't recall if that specific sentence came out of my mouth.
Okay. Thank you. No further questions.
Cross, I guess. Sorry. Ma'am, did you know your sister to have any enemies or anybody who'd want to hurt her?
Not at all. Again, my sister was the epitome of good. She was incredibly well liked by everybody, and she had no enemies, to my knowledge.
And when you're sitting with these detectives, this was on October 21st?
Correct.
What was your frame of mind at that time?
I was in a complete state of shock. I was living my worst nightmare. It was the worst day of my life. My sister, my best friend, was just murdered viciously. And again, I wasn't myself. I tried to help as much as possible. I talked about a lot of people that she had come in contact with. And I threw out words very casually, which, I had no basis to use those words.
Do you have any reason whatsoever to believe that Aaron Pergament was a stalker?
Not in the slightest. Aaron Pergament, I've subsequently met, is a very kind, respectful, upstanding human being.
Thank you. Nothing further.
Can you redirect?
Did you know whether or not your sister gave Aaron Pergament a key to her apartment?
I do not know, but I do not think she did.
You don't think? Okay, but you don't know, correct?
I do not know specifically.
Thank you. No further questions.
During the trial, prosecutors presented surveillance footage placing Jackson Bolanos near Woll's home and forensic evidence, including Woll's blood on his jacket. The defense argued that while Jackson Bolanos had lied to police, there was no direct proof that he committed the murder.
And just after lunch, and we received a note a little while ago indicating that you are still deadlocked as to 2 of the counts. You've reached a verdict as to 2 of the counts, and you are not making any more progress. Is that correct?
Yes, Judge.
Who is your foreperson? You are actually juror number 15? Okay. Juror number 15, we will take a partial verdict as to the 2 counts that you have reached a verdict on, and if you haven't reached a verdict, just say deadlocked, okay? And if you have reached a verdict, read what's next to the box you check marked under that count, Okay, so the clerk is going to take the verdict from you. Please stand. And after she reads the count and the charge, you read what's next to it, or deadlock if you're deadlocked. Thank you.
In the case of the people of the state of Michigan versus Michael Manuel Jackson Bolanos, Mr. Foreperson, will you please read the verdict form as marked as to count 1, first-degree felony murder?
Deadlocked.
As to count 2, first-degree premeditated murder?
Not guilty.
As to count 3, home invasion first degree?
Deadlocked.
And as to count 4, concealing facts or misleading the police?
Guilty.
All jurors, please stand and raise your right hands.
Members of the jury, listen to your verdict as recorded by the court. You do say upon your oath that you find Michael Manuel Jackson Bolanos hung as to count 1, first-degree felony murder, not guilty as to count 2, first-degree premeditated murder, hung as to count 3, home invasion first degree, and guilty of count 4, concealing facts or misleading the police. So say you, Mr. Foreperson, so say you, members of the jury.
After deliberation, the jury acquitted Jackson Bolanos of first-degree murder, but found him guilty of lying to police. They were deadlocked on felony murder and home invasion charges, which were later dismissed by the judge. Jackson Bolanos received a sentence of 18 months to 15 years for providing false information to authorities.
We are absolutely convinced overwhelming evidence points to him as the murderer, and disappointed in the justice system, but we're glad he's going to remain in jail for the next few months and hopefully longer. And we're going to appeal the legal issues as much as we can. Our family has been devastated by this whole process and the antics of the defense attorneys who have used lies, misdirection, made up stories, hypotheses that have all been proven untrue. So our family's just trying to persevere and get through this nightmare.
Samantha's family, including Monica, expressed deep disappointment with the trial's outcome, insisting that Jackson Bolanos was responsible for the crime. They continue to push for justice while preserving Samantha's legacy of community service and interfaith unity. The case of Casey Noel, daughter of former Clark County Sheriff Jamie Noel, is part of a larger financial misconduct scandal involving her family. The investigation into the Noels began when authorities uncovered that Jamie Noel had misappropriated funds from the Utica Township Volunteer Firefighters Association, also known as New Chapel EMES. Over nearly 2 decades, he siphoned off millions of dollars using the stolen funds for vacations, luxury cars, and other personal expenses. As the investigation progressed, law enforcement discovered that the misconduct extended beyond Jamie Noel himself. His wife, Misty Noel, and their daughter, Casey Noel, were also implicated. Misty was accused of misusing approximately $660,000 in stolen funds, while Casey was found to have spent over $100,000 for personal benefit. Neither had reported these amounts as income on their tax returns. In August 2024, Jamie Noel pleaded guilty to over 25 felony counts, including theft, tax evasion, and money laundering.
So as I've analyzed this, I've come to the conclusion that it's a very substantial sentence, considering that these are level 5s and level 6 felonies. And I also listened today carefully. And not one of them indicated that they wanted you to spend more time in prison. They wanted you to remember your deceased brother for the rest of your life and what you did to his children. Some of them want you to suffer. And you can understand that, I would hope, considering how you betrayed everybody that you possibly knew. everybody that thought you were their friend. Matt Owen could barely look at you. He held you up as a father figure. Supported you when you were telling everybody it's a witch hunt. He still believed you. Yet you deceived everybody. Witch hunt. Way to deflect responsibility. So, with reluctance, I will accept the plea agreement.
The court sentenced him to 15 years in prison for his role in the scheme. His conviction set the stage for further legal action against his wife and daughter. Shortly after, Misty filed for divorce from Jamie, further complicating the family's legal battles. Casey's case moved forward as prosecutors built evidence against her.
You're going to be pleading guilty to 5 counts of theft as a level 6 felony and 4 counts of tax evasion as a level 6 felony. Do you understand the state would have to prove each and every element of each one of those counts beyond a reasonable doubt before you could be found guilty?
Yes.
A level 6 felony has a range of imprisonment of no time in jail if it's treated as a misdemeanor to 2 1/2 years at the Indiana Department of Corrections, with the advisory sentence being 1 year and up to a $10,000 fine. Do you understand that?
Yes.
Has anybody offered you anything of any value to get you to plead guilty here today?
No, sir.
Has anybody threatened you, coerced you, forced you, or anyone else to get you to plead guilty here today?
No, sir.
In January 2025, she appeared in Clark County Circuit Court, where she pleaded guilty to 5 counts of theft and 4 counts of tax evasion, all classified as level 6 felonies.
And Casey, were you in Clark County, Indiana between June 1st, 2019 and December 31st, 2019? Yes. And at that time, did you knowingly or intentionally exert unauthorized control over property of Utica Volunteer Firefighters Association with the intent to deprive them of any part of its value or use? Yes. And did that property have at least a value of $750 but less than a value of $50,000? Yes. And was that in the form of American Express charges? Yes. Again, Casey, were you in Clark County, Indiana on January 1st, 2020 and December 31st, 2020? Yes. And at that time, did you knowingly or intentionally exert unauthorized control over property of Utica Township Volunteer Firefighters Association with the intent to deprive them of any part of its value or use, and that property had at least $750 value but less than $50,000 value? Yes. And again, was that in the form of American Express charges? Yes. Casey, were you in Clark County, Indiana between January 1st, 2021 and December 31st, 2021? Yes. And at that time, did you knowingly or intentionally exert unauthorized control over property of Utica Township Volunteer Firefighters Association with the intent to deprive them of any part of the use or value of that property? Yes. And that property had a value of at least $750 but less than $50,000? Yes. And again, was that in the form of American Express charges? Yes. And again, were you in Clark County, Indiana between January 1st, 2022 and December 31st, 2022? Yes. And at that time, did you knowingly or intentionally exert unauthorized control over property of Utica Township Volunteer Firefighters Association with the intent to deprive them of its value or use? Yes. And was that a value of at least $750 but less than the value of $50,000? Yes. And again, was that in the form of American Express charges? Yes. Casey, were you in Clark County, Indiana between January 1st, 2023 and December 31st, 2003? Yes. 2023, I'm sorry. Yes. And again, did you knowingly or intentionally exert unauthorized control over property belonging to Utica Township Volunteer Firefighters Association with the intent to deprive them of its value or use? Yes. And was that a value of at least $750 but less than the value of $50,000? Yes. And again, in the form of American Express charges? Yes. And Casey, in February 18th, 2020, were you in Clark County, Indiana? Yes. And at that time, did you make a false tax return or a false tax statement with the intent to evade the payment of that tax or any part of it? Yes. And were you in Clark County, Indiana on March 9th, 2021? Yes.
And at that time, did you make a false tax return or a false statement on a tax return with the intent to evade the payment of that tax?
Yes.
And were you in Clark County, Indiana on February 20th, 2022?
Yes.
And at that time, did you make a false tax return or make a false statement in a tax return?
Yes.
And was that to evade the payment of that tax?
Yes.
And lastly, were you in Clark County, Indiana on April 8th, 2023?
Yes.
And at that time, did you make a false tax return or a false statement on a tax return?
Yes.
And was that with the intent to evade the payment of that tax?
Yes.
Judge, I believe that satisfies the factual basis.
Perhaps. Question, Mr. Bush-Saltel. During Mr. Noel's sentencing, he indicated that he prepared everybody's tax returns. How did she know they were false?
And Judge, I would note that legally, I believe there is an obligation to know what is on your tax return, whether or not you're the person who prepared it.
Well, I don't disagree with that, but how did she know it was false?
Your Honor, the tax returns are expressly associated with the American Express charges. And therefore, I believe it would satisfy the factual basis that Ms. Noel was aware that she was using the credit card, incurring charges with the money belonging to Utica and not reporting that as a profit on her tax returns.
Mr. Hurdle?
Your Honor, are you asking me if I have questions or specifically about those things?
Do you have any questions or comments concerning that question?
Casey, did you sign your tax returns?
No.
Is that a no?
Just one moment, Judge.
Ms. Bush,
Case,
was that a no?
Judge, we are going to clarify. It's a no, but there's a particular reason behind it.
All right.
Mr. Hurdle can ask a clarifying question, or I can.
I prefer that counsel for the defendant clarify that, Your Honor.
All right.
And Casey, you were aware that your father was preparing your tax returns to be filed online. Is that correct?
Yes.
All right. And when you say you didn't sign those, you didn't physically sign a paper, correct? All right. But you were aware regarding the credit card charges that you just pled guilty to that those were not included on your taxes. Is that correct? Does that satisfy, Judge?
She admitted to unauthorized use of funds from New Chapel EMS, primarily through American Express charges, and acknowledged that she had failed to report these transactions on her tax filings.
How did you develop this sense of entitlement?
I followed the wrong examples, and I'm sorry.
I'm sorry.
I followed the wrong examples, and I'm sorry.
Casey, I believe you're a victim of your father and perhaps a victim of your mother. The lifestyle that they chose to live. You're a young person, I could somewhat see, but you're 27, 28 years old, you're an adult. I don't understand exactly why you would think that would be acceptable. What have you learned?
Biggest thing I've learned is to not blindly trust people, even family.
During the sentencing hearing, the judge pressed Casey on her role in the financial scheme, questioning how she had developed a sense of entitlement to use public funds for personal expenses. Casey responded with remorse. The judge acknowledged that she may have been influenced by her father's actions, but emphasized that as an adult, she was still responsible for her choices.
Casey, how old are you?
28.
Court would find that Casey Noel is 28 years of age. She understands the nature of the charges against her, which she's pleading guilty, understands the possible sentence for the crime. Plea of guilty is freely and voluntarily made. There is a factual basis for the plea. The court will accept the plea and find Casey Noel guilty of counts 1 through 9, all as level 6 felonies. Pursuant to the plea agreement, count 1, 30 months with 25 months suspended. Count 2, theft, level 6 felony, 30 months, 25 months suspended. Count 3, theft, a level 6 felony, 30 months, 25 months suspended. Count 4, theft, a level 6 felony, 30 months, 25 months suspended. Count 5, theft, level 6 felony, 30 months, 25 months suspended. Count 6, tax evasion, level 6 felony, 30 months, with 26 months suspended. Tax evasion on count 7, 30 months, 26 months suspended. Count 8, tax evasion, level 6 felony, 30 months with 26 months suspended. Count 9, tax evasion, level 6 felony, 30 months with 26 months suspended. So that'll be a total of sentence of 60 months, 5 years to the Indiana Department of Corrections, with 51 months suspended to probation. Counts 1 through 6 shall run consecutive to one another, with all other counts running concurrent. You'll receive credit for the days you've already served. You've agreed to pay restitution to New Chapel in the amount of $108,660.59. Pay restitution to the Indiana Department of Revenue to $5,049. And you should thank your lawyer that she convinced me to not add any additional fines.
The court sentenced Casey to 5 years in prison, with 51 months suspended to probation. She was ordered to serve 4.5 months in the Harrison County Detention Center and to pay restitution of $108,660 to New Chapel Fire and $5,049 to the Indiana Department of Revenue. The judge warned her that any violation of her probation would result in serving the remainder of her sentence behind bars. Meanwhile, Misty Noel's legal proceedings remained unresolved. Her trial, originally scheduled for February 2025, was postponed as plea negotiations were ongoing. Prosecutors continued to pursue charges related to her alleged involvement in the financial mismanagement at New Chapel EMS. In August 2016, 27-year-old Adam Hilarie, a single father from Auburndale, Florida, was searching for companionship and connected with 18-year-old Haley Bustos on the dating app Plenty of Fish. Unbeknownst to him, Bustos was working with Andre Warner, Gary Gray, and Joshua Ellington to set up a robbery. On August 18th, Adam and Haley went on a date, during which he invited her to his apartment on Sunset Avenue. He had no idea she was scouting his home for valuables. After leaving, Haley reported back to Warner and the others, providing them with details about the apartment layout and items they could steal. The group then devised a plan to return the next day to rob him. On August 19th, Warner, Gray, and Ellington arrived at Adam's apartment under the pretense of hanging out. Their real intention was theft, but the situation escalated. After taking valuables, including 3 televisions, a gaming console, and personal items, Adam was fatally harmed before the group fled. That evening, Adam's roommate, John Hunn, arrived home and noticed the front door open, which was unusual as they always used the back entrance. Inside, the apartment was ransacked with missing electronics, furniture overturned, and wires pulled from the walls. In shock, he briefly ran from the scene before realizing he needed to call 911. Detectives quickly launched an investigation, tracking Adam's final communications. Haley Bustos' name surfaced, leading police to question her. Shortly after, she was arrested for an unrelated probation violation, and under interrogation, she confessed to her involvement in the setup. Her statements led authorities to Andre Warner, Gary Gray, and Joshua Ellington, who were all charged with first-degree murder, armed robbery, and conspiracy.
What was being said and by whom at this point?
Everyone was asking me
where he stayed and
Talking
And how
about
far?
Adam?
yes,
Okay.
and how far. And
Was there a discussion about who was going to be involved in the robbery?
I'm not sure.
Okay. What happened after Evelyn was asking you about where he lived?
She told us to get in the car.
And who did she tell to get in the car?
Drew, me, and Gary.
And what about Josh? Was he involved at this point?
They were looking for a getaway driver, and Josh volunteered himself.
Okay. Why did you need to go? What was going to be your role?
To show him where the house was.
Okay. Josh was going to be the getaway driver. What was Andre Warner's role going to be?
To go inside.
I would object unless she can specify the source of the information, who she got it from.
Was there a discussion?
Rephrase the question, ma'am.
Was there a discussion about who was actually going to go into Adam's apartment?
Yes.
And who was talking about that?
Drew.
And what did he say?
Him and Gary were going to go in the house.
Okay. Now, there were other people at Evelyn's apartment, you told us?
Yes.
What were they doing at this time?
I'm not sure.
Were they involved in this conversation?
No.
And what vehicle was going to be taken?
Drew's.
Did the four of you get into Andre Warner's vehicle?
Yes.
Who was driving?
Josh.
And who was in the front passenger seat?
Drew.
And who was in the back seat?
Me and Gary.
Did Mr. Warner get out of the vehicle?
Yes.
And what happened?
They went inside.
Who's they?
Oh, he went inside.
Was Gary still inside?
Yes.
And what happened after that?
They were bringing stuff to the car.
Who was bringing stuff to the car?
Gary and Dre. One by one.
Were you able to see what they were?
No.
Okay. You didn't see any of that?
The only thing I seen was when they opened the back door and put the flat screen TV in the back.
Okay. Did they go back and forth between Adam's apartment and Mr. Warner's vehicle more than one time?
Yes.
Do you remember how many times?
Like 2 to 3.
Okay. And what happened after that?
I heard a shot.
Now, when you heard the shot, who was inside the apartment?
Dre and Gary.
Okay. And what happened after that?
They ran out.
And who ran out first?
Gary.
And Mr. Warner came out second?
Yes.
And what did you see?
Dre slipped, and when he got in the car, something hit the floor, but I'm not sure what it was.
Something hit the floor?
Yes.
Okay. Now, when Gary came out, did you see him with a firearm?
No.
What about Mr. Warner?
I'm not really quite sure.
You're not sure. But you heard something hit the floor when he got in the vehicle?
Yes.
What did it sound like?
Heavy.
Something heavy. And what happened after that?
We took off.
Okay. And were you guys heading back to Evelyn's apartment?
Yes.
Was there any conversation in the car after you left Adam's apartment?
Yes.
What was being said and by who?
They were laughing.
Who's they?
Jerry and Gary.
What were they laughing about?
How he was begging for his life.
Was Mr. Warner making these statements?
Yes.
What specifically did he say?
And how he was begging for his life, saying, "Please don't take my life. I have a 5-year-old daughter."
And he was laughing about that?
Yes.
What were you thinking at that point?
I was crying.
Did they make any other statements?
I'm not sure.
Do you remember whether there was a statement made about where he was?
Yes.
Tell us about that and who said that.
Gary said that he shot him in the arm.
When Gary said he shot him in the arm, who was he referring to?
Drew.
So did you think that Adam had only been shot in the arm at that point?
Yes.
Do you remember any other statements that they made at that point? I'm talking specifically about the car ride.
He said they just take anything but just don't kill him.
In March 2020, Warner stood trial with prosecutors presenting Haley's testimony, forensic evidence, and crime scene details from the victim's roommate, John Hunn.
I wasn't there all the time. I was back and forth between my ex-girlfriend's house, stuff like that, so.
Okay. Now, let's talk about Thursday, August 18th of 2016. Were you staying at Adam's house on that particular date? That would have been the day before his body was found.
No, ma'am. I was there until about 11 o'clock that night, and I left. I went back to my ex-girlfriend's house for the night.
Did you work at that time?
Yes.
And what time would you normally have gotten off work?
Somewhere around 4-ish.
And did you go to the apartment that Thursday, to Adam's apartment?
Yes.
And was Adam there when you got home?
Yes.
Did there come a time when he left?
Yes, ma'am.
And tell us about that. What happened when did he return to the apartment?
Yeah, he said he met a girl. I got home, was gonna take a shower and stuff. We stood around and talked. He said he met a girl online, that he was gonna go pick her up, take her on a date. And he said he was going to get her and come back before they took off. So I got in the shower. By the time I got out, got dressed and stuff, him and her were already back, hanging out.
Was this a girl that he met on Plenty of Fish?
Yes.
Now, when he arrived there at the apartment with the girl, was this a girl that you had ever seen before?
No.
Was she introduced to you?
Vaguely.
Okay. What do you mean by that?
I don't know if there was a proper introduction, like names and handshakes and stuff. Like it's been a while, so I don't quite remember 100%. But
Okay.
I believe it was just a cordial, hello, how are you type of thing, and then we went our separate ways.
Do you know how long the female and Adam were there, or did you end up leaving before them?
No, when I got out of the shower, I believe it was no longer than an hour, about a half hour, and then they took off to go bowling, I believe.
Okay. So when they left, you were still at the apartment?
Yes,
And then I think you told us you ended up leaving.
about 11 o'clock that night.
Okay. Did you have any more communications with Adam that night?
Through text message, yes.
And do you remember around what time that might have been?
It was late. I don't quite remember. I don't even remember the exact time I left the apartment to head to my ex's house, but it was late, maybe around midnight. The last text I got from him, somewhere close to that.
At that time, if you remember, was he still with the female?
As to my knowledge, yes. I believe I asked him what he was doing. I think when he got back to the apartment and I wasn't there, he texted me to see where I was. I told him I was at my ex's. I asked him what he was doing, and I think he said he was hanging out with her. And that was the end of it, I believe.
Okay. Now let's move on then to the next day, that Friday, August 19th. Did you work that day?
Yes.
And did you get off your normal time around 4?
3, 4 o'clock, something like that, I believe.
Where did you go when you got off of work?
To the apartment.
Now, did you have your own key to get into the apartment?
No, there was one key, and if I had it, I'd leave it outside under a brick. If he had it, he'd leave it outside under the brick. So it's just kind of community, I guess you'd call it.
And what door would you and Adam normally use when you entered the apartment?
I guess you would consider that the back door.
So where you would park your vehicles?
Yes.
Now, when you arrived home, was Adam's vehicle there?
Yes.
Did you try to go into the back door?
Yes, it was locked.
Did you check to see if the key was around?
Yes, because I believe one of the messages I texted him, one of the last messages was, leave the key out, I'll be home after work, or something like that.
Okay. Was the key there?
No.
Did you attempt to get Adam's attention so that he could let you into the apartment?
Yeah, I knocked. I looked in windows. It looked like nobody was there, so I just assumed maybe he left with his brother or someone else came, a friend came, and he took off with them.
So what did you do?
I sat there and just was gonna wait.
How long do you think you sat there?
Probably about an hour and a half, 2 hours.
Were you sitting right in the doorway where the back door of the apartment was?
Basically leaning against it.
Okay. And then what happened after that?
It was middle of summer. It was hot. I was gonna get on the bicycle and ride to the store, get something to drink.
Okay, tell us about that.
I got on the bike. I left out the entrance of the apartments, or to the parking lot of the apartments. Just like out of the corner of my eye, I noticed our front door open, like swinging in the wind or whatnot.
So when you left, you were riding your bike in the direction to pass the front door of the apartment?
No, if the apartments are running long ways like this, I would come out and I would have went left. But when I got out, it caught my eye, one of the doors open, because nobody really used any of their front doors. It was kind of like everyone used the doors where they parked at in the back.
Did you and Adam ever use your front door?
No, that door was never open one time while I was there.
So what did you do when you saw that?
Became suspicious.
And what did you do?
Slowly made my way that way, I guess you would say, because it was odd, because I knocked on the doors, no one was there, but his car was there, so like things started in my head, something might not be right. So I peek in and I see a mess, like things destroyed and TVs missing, and I'm just like, dang, they robbed us, not thinking that he was even there.
Okay. And did you go further into the apartment?
Yes, ma'am.
Tell us about that.
I want to say that I walked in just looking around, seeing what was gone, and then I made it to the kitchen where he was.
What did you do?
To be honest, I don't really know. I was kind of in shock, I guess. The next thing I remember is like hauling Bud on a bicycle down the road and then saying to myself, what are you doing? Where are you going? You got to go back. So then when I went back, I just wanted to like make sure that I seen what I seen. Like I said, I guess I was in shock. I don't remember a lot of this, but I guess I walked in again and kind of looked and called 911 after that.
Okay. So you're the one that actually alerted law enforcement what happened to Adam?
Yes, ma'am.
Did you tell him on the 911 call what you saw?
Yes, ma'am.
Now, you mentioned that when you first walked in, you noticed that things were missing. Can you tell us more about that?
The obvious thing that was missing was the TVs in the living room. We actually, the 2 nights prior had all 3 TVs in the living room watching 2 games and playing video games at the same time. So that was pretty obvious. And all the wires were snatched out of the wall, like just strewn across the living room. And
That was the thing that stuck out most.
yeah, that's how I knew something happened at that point, because all the TVs were gone.
A critical moment came when the jury heard a jailhouse phone call between Warner and his grandfather, where he discussed shot residue and the need to shower to remove evidence. Prosecutors argued that this demonstrated consciousness of guilt, while the defense claimed the conversation was misinterpreted. After a 3-week trial, the jury convicted Warner of first-degree murder, robbery, and burglary. Prosecutors sought the death penalty, citing premeditation and cruelty.
Sentencing verdict: we, the jury, find as follows as to Andre Maurice Warner in this case. As to the aggravating circumstances or factors, we, the jury, unanimously find that the state has established beyond reasonable doubt the existence of the aggravating factor that the defendant was previously convicted of another felony involving the use of the use or threat of use of violence to a person. That is case number CF 11-25469, domestic battery by strangulation, and the jury checked yes. As to number 2, we, the jury, unanimously find that the state has established beyond reasonable doubt the existence of the aggravating factor that the defendant was previously convicted of another felony involving the use or threat of violence to a person, case number CF 14-08-255, robbery by intimidation. Jury have checked the option yes. As to factor 3, we, the jury, unanimously find that the state has established beyond reasonable doubt the existence of the aggravating factor that the murder was committed while the defendant was engaged in a robbery. The jury checked the option of yes. Number 4, we, the jury, find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the murder was committed while the defendant was engaged in a burglary. The jury checked the option of yes. Factor number 5, we, the jury, unanimously find that the state has established beyond reasonable doubt the existence of the aggravating factor that the murder was committed for the purpose of avoiding or preventing a lawful arrest, and the jurors have checked yes. Factor 6, we, the jury, unanimously find that the state has established beyond reasonable doubt the existence of the aggravating factor that the murder was committed for financial gain. The jury checked the option of yes. Factor 7, we, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the murder was especially heinous, atrocious, or cruel. The jury checked the options of yes.
The jury opted for the prosecutor's recommendation, and Warner was sentenced to death. Haley Bustos, the one who set Adam up, pleaded guilty and received 25 years in prison in exchange for her testimony. Gray and Ellington also received long prison sentences. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.